Good morning and welcome to the April 24th, 2023 Land Use Hearing Officer meeting. I'm Pamela Jo Hatley and I'll be serving as your Land Use Hearing Officer this morning. Before we get started, if you're able, please stand for the Pledge of Allegiance. All right, thank you. Again, I'm Pamela Jo Hatley, and I'll be serving as your Land Use Hearing Officer this morning. Right now, if you have any devices that make noise, would you please silence them at this time? Thank you for that. I'd like to introduce Mr. Tom Hisney with the Development Services Department. Mr. Hisney will introduce staff, agenda changes, withdrawals, and any continuances this morning.
Good morning, Ms. Hatley. Good morning, everyone in the audience. To my right is Carmen Mason of Development Services staff. To my left is Mary Dorman of the County Attorney's Office. Throughout the course of the hearing, other planners from Development Services will be presenting their cases at the podium, and they'll be introduced throughout the course of the hearing. So right now I'm going to read into the record of withdrawals and continuances from today's hearing that are published on the agenda. Item A1, Special Use Application 22-1657. The applicant is Todd Seamy. This application is out of order to be heard and is being continued to the May 22nd, 2023 Land Use Hearing Officer meeting. Item A2, Variance Application 23-0005. The applicant is John Grissar. This application is out of order to be heard and is being continued to the May 22nd, 2023 Land Use Hearing Officer meeting. Item A3, Variance Application 23-0048. The applicant is Teresa Hernandez. This application is out of order to be heard and is being continued to the May 22nd, 2023 Land Use Hearing Officer meeting. Item A4, Special Use Application 23-0106. The applicant is the Redlands Christian Migrant Association. This application is being continued by staff to the May 22nd, 2023 Land Use Hearing Officer meeting. Item A5, Variance Application 23-0142. The applicant is Mark Bentley. This application is out of order to be heard and is being continued to the May 22nd, 2022 Land Use Hearing Officer meeting. Item A6, Variance Application 23-0164. The applicant is Lee Ann Law. This application is out of order to be heard and is being continued to the May 22nd, 2023 Land Use Hearing Officer meeting. Item A7, Variance Application 23-0175. The applicant is Jason Honesty. This application has been withdrawn by the petitioner. Item A8, Special Use Application 23-0177. The applicant is First Watch Restaurants. This application has been withdrawn by the petitioner. Item A9, Variance Application 23-0182. The applicant is Bert Thomas. This application is out of order to be heard and is being continued to the May 22nd, 2023 Land Use Hearing Officer meeting. Item A10, Special Use Application 23-0187. The applicant is El Patio Hookah Lounge. This application is being continued by staff to the May 22nd, 2023 Land Use Hearing Officer meeting. Item A11, Special Use Application 23-0227. The applicant is Phoenix Waters. This application is out of order to be heard and is being continued to the May 22nd, 2023 Land Use Hearing Officer meeting. Item A12, Variance Application 23-0228. The applicant is Claudia Valentine Henry. This application has been withdrawn by the petitioner. And then finally, item A13, Variance Application 23-0276. The applicant is David Scott Jambudis. This application is out of order to be heard and is being continued to the May 22nd, 2023 Land Use Hearing Officer meeting.
Thank you, Mr. Hisney. All right. So again, if you would please silence any devices that you might have. The agenda today consists of items that require a public hearing by a hearing master. I will conduct a hearing on each item and will submit a decision within 15 working days after the conclusion of today's public hearing, except for fee waivers, which will have a decision within 5 working days of the public hearing. My decisions will be filed with the clerk of the Board of County Commissioners. The hearings today are informal. I will ask questions related to the scope of direct testimony and may call and question witnesses as I deem appropriate. I will decide all questions of procedure. I will take evidence, but I will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony shall be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding of fact unless it would be admissible over objections in a civil court action. The order of presentation shall be as follows. For variances, first of all, Mr. Hisney will call the case. The County Development Services Department will have 5 minutes to present its report and findings. The applicant and applicant's witnesses will have 15 minutes to present the proposal. Proponents will have 15 minutes to present arguments in support of the proposal. Opponents will have 15 minutes to present arguments against a proposal. County staff will then have 5 minutes to present any amended findings or comments, and the applicant will have 5 minutes for rebuttal or summation. In special use cases, Mr. Hisney will call the case. The applicant and the applicant's witnesses will have 15 minutes to present the proposal. County Development Services will have 5 minutes to present its report and findings. Proponents will have 15 minutes to present arguments in support of the proposal. County staff will have 5 minutes to present any opponents then will have 15 minutes to present arguments against a proposal. County staff then will have 5 minutes to present amended findings or comments, and the applicant will have 5 minutes for rebuttal and summation. The 15 minutes that are for proponents and opponents is the total time allotted among all speakers. So if there are a number of persons who wish to speak, the 15 minutes will be distributed among you. If you have a single spokesman who you wish to designate to speak for the group, you're welcome to do that. When you come to the microphone to speak this morning, please first state your name and address for the record and speak into the microphone so your testimony can be heard and recorded. The meeting today is being recorded. When you're finished speaking, please see the clerk to my left, right here, and sign in for the record. Now we will hear from the County Attorney's Office who will state the legal requirements and procedures for appeal.
This is Mary Dorman from the County Attorney's Office. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, county staff, and any interveners, each of whom may be represented by legal counsel. The following shall have standing to appeal a decision of the hearing officer or to intervene in an appeal. 1, the applicant, or 2, anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend that the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside the record created at today's hearing could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments you make today and repeat them to the appeals board. Thank you.
Thank you, Ms. Dorman. All right, all testimony today must be taken under oath. So if you plan to speak today, please stand and raise your hand, and I'll swear you in. If anyone is online, please also do the same. All right, do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth? All right. Thank you, Mr. Hisney. Would you please call the first case?
Okay, so on today's agenda, we have no vested rights cases, which then takes us to Section C of the agenda, which are fee waiver requests, and we have 2 fee waiver requests today. First one is item C1, case number 23-0274. The applicant is Michael Aziz. The applicant, pursuant to procedures in our County Development Review Procedures Manual, the applicant requests consideration of an exception, fee waiver exception by the land use hearing officer for a fee waiver application that cannot be approved by the administrator. The fee waiver is requested by the applicant on the basis of staff error in connection with an improper issuance of a building permit and subsequent construction of a shed located within a wetland setback area. He is required to come to the hearing officer for consideration of this fee waiver because under county procedures, staff cannot approve a fee waiver on the request of staff error.
All right. Thank you, Mr. Hisney. Is the applicant here? Please come forward. Please state your name and address, and then proceed with your testimony.
My name is Michael Aziz. I live in 6803 Spencer Circle, Tampa, Florida, 33610. And do you want me to sign or just?
Please just first state your case, the facts behind why you're here today and why you're seeking the fee waiver and supporting testimony that you have.
Sure. So I want to put a utility shed on my lot, my land, and this is the first time for me to pull a permit. So I went online, I applied. They asked me for a lot of documentations, where I'm going to put it, location, the size, how it's going to be built, all of that stuff. I fulfilled all of that, got the approval, gave me the permit. I made the order, get delivered, and then I had like 2 inspections because I'm missing stairs, few things. After that, I got certificate of completion, so which is completed. 4 days later, I got from the human resources saying that they didn't look at that paperwork before they give me that. And because it's near to the water, because I live on a lake, so now I have to go to the process from the beginning. And the shed is long, my land is like on the water, so it's very hard for me to move it. It's been anchored already, and the lot is not wide enough even to move it back. So I'm pretty much stuck with it now, and if I know that from the beginning, I might consider like a smaller shed or maybe cancel the idea, but now I bought it, it's anchored, it's there. And you told me that I can go through a variant, which is 2,000 something, and I don't feel like I should be paying this because, it's not my mistake from the beginning.
All right, thank you. I actually don't have any questions for you. I've reviewed the case. Okay. So if that's all of the testimony you have, that's fine. I need you to sign in with the clerk.
Sure.
All right. All right, is there anyone here or online who wishes to speak as a proponent in support of this case? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this case? All right, don't hear anyone. Development services, anything further?
No, ma'am.
All right. And applicant, you had nothing further, is that correct? You had nothing further. All right, thank you. We'll close the hearing then on fee waiver application 23-0274.
All right, our next case is item C2, fee waiver application 23-0289. The applicant is David Scott Jambutis, asking for a LUHO exception for a fee waiver request. The applicant requests consideration of an exception by the land use hearing officer for a fee waiver application that cannot be approved by the administrator under county procedures. The fee waiver is requested by the applicant on the basis of staff error in connection with the improper issuance of a building permit and subsequent construction of a single-family home not meeting some of the Citrus Park Village development standards.
All right, thank you, Mr. Hisney. Applicant, please.
Good morning.
Good morning.
Jeannie Gambutis, 22810 Bay Cedar Drive, Lano Lakes, Florida, 34639.
All right, thank you. Please just proceed and tell me the facts and behind this fee waiver request and any supporting testimony you have.
Okay. We submitted a permit to build this home for clients for ours, the bishops who live out of state. We filled in everything online like we do for all of our homes. The permit got approved and we started building the home. In fact, we were more than halfway done with the home when there was a stop work order put on the home due to the Citrus Park alterations that should have been told to us while the permit was being processed. Never told to us. Had they been done at that part, we would have changed it during the planning process, put them on the plans. So that was no fault of ours. So that's why we don't feel that we should pay it. And in fact, it's causing a lot of issues for our clients and for us, obviously. So, and I've been in contact back and forth with Mr. Israel and Ms. Carmen. So we're trying to get this resolved.
Okay.
But it was not our fault. We would have done what we would have done had they told us.
Okay. Thank you. And again, I really have no questions for you. I've
Right.
reviewed the case. I just need you to sign in with the clerk.
Thank you very much.
All right. Thank you, ma'am. All right. Is there anyone here or online who wishes to speak in support of this request? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this request? All right. Don't hear anyone. Development services, anything further?
No, no, ma'am.
All right. And applicant, you had nothing further, right?
Oh, no.
Okay, thank you. That's all right. All right, so we'll close the hearing on fee waiver request 23-0289.
That concludes section C of the agenda. We have no remands or reconsideration requests. That takes us to section F of the agenda, site development variances. We have one case, item F1, application 23-0220. Applicant is Phoenix Waters LLC, requesting a variance to reduce landscape buffer width for off-street vehicular use area. Staff findings will be presented by Carla Shelton.
Good morning. The applicant is requesting a variance from the 8-foot landscape buffer width requirement, section 6.0 46.06.04D of the Land Development Code. The applicant's specific request, as shown on the plan submitted on March 6, 2023, is to allow for a reduced buffer width with increased landscape density. The landscape buffer per LDC section 6.06.04D, a driveway into a parking area shall be bordered by a landscape buffer a minimum of 8 feet in width. The applicant requests a reduction in the width of the buffer, with the width to vary between 4.6 feet and 5.8 feet for a length of approximately 72 feet. The applicant proposes providing a total of 5 ornamental species trees in this buffer area in place of the normally required 3 trees. The applicant also proposes providing a total of 3 ornamental species trees in the buffer area on the opposite side of the driveway in place of the normally required 2 trees. Staff findings. The proposed landscape trees are an acceptable species classification, which is ornamental species, for the reduced buffer width and limited growing area. The species of trees and hedge material should be approved by the Natural Resources section of the Development Services Department during the review of the site construction plans.
All right. Thank you. All right, applicant?
Hello, I'm Matthew Campo, 1725 East Fifth Avenue. I'm here representing the applicant. I'm going to use the overhead here, if I could. Let's see. Just to kind of give you an orientation of what Carlo was referring to. Here on the overhead, this particular area, this is the buffer that we're looking at. This is an existing driveway that comes into the site. There's actually an approved Aussie grill here, and then there's this stormwater vault, which is kind of like, this is really the hardship aspect of, you know, you don't usually have an existing site. That the site was very old. It's been unoccupied, and the buildings have been closed for about 7-8 years now. They've been trying to redevelop it. So this particular vault being kept was not just a financial component, because they're very expensive to construct. It also provides the stormwater for site. So that affected the location of the Aussie Grill, which then this particular use everything got pushed to the west. So just to kind of give you an idea of what that particular corridor looked like. Let's see. Actually. So essentially, this is a parcel that's on the southwest corner that's existing. It's not part of this development. This is the driveway I mentioned, and then the use we're talking about would be right here.
Okay, and is the driveway on the parcel, or is it?
It's like, the answer was yes, it is on the parcel. It's a shared driveway. Mm-hmm. So this is, again, this is the driveway here. They use it. And then this property, which was previously, this was a gas station. There's another use in the back, which is retail. Those are the ones that have been closed. They're redeveloping this building in the back, and this is new users. But that's the corridor that all these properties would have to use.
I see. Okay. Thank you.
That kind of establishes, the hardship of the geometry, which results in the limitations on the east to west, and of course results in the narrowing of the buffer. Mm-hmm. Everything Carla had described, it's consistent with what we proposed. We provided for you our justification for the request. I think the stormwater vault was like probably one item that was not in there that I think is a helpful component in your consideration of this. As far as I was going to ask if you had any questions with our justification, if there's anything that you want us to elaborate more on.
I have reviewed them, but it was kind of hard for me to understand the site plan, but this is all one parcel with these 2 uses on it. Is that
yes? The
case?
Front portion is one. Actually, I should rephrase that. The front portion is one parcel recently platted to 2 lots.
It is
so
2
each
lots.
user will have
Okay.
its own lot.
All right, so they're two separate lots.
Yeah, originally it wasn't, when we submitted this application, that wasn't the case, but
I
that
see.
occurred since.
I see. And the stormwater vault is on the other lot, is that correct?
That's correct.
But it affected development of both. Does it
Correct.
serve both?
Yes, it'll serve both.
Okay.
Yeah, it'll serve both. And like I said, it's a feature that's in the ground, to replace that would be in the hundreds of thousands of dollars range.
Yep.
And, this site, we've actually been involved with this site for almost 8 years. It's gone through multiple minor modifications and just can't seem to get the combination of users. A lot of people keep dropping off. So from that standpoint, while financial is not a component, it has contributed to, buildings with, that are decaying and they've been closed. They're all chain linked, fenced in. And so, this particular, we're like the last piece of the puzzle. With this approval, that particular parcel gets approved, and then finally they can kind of finish that property, make it viable for the neighbors. It's food uses, which that area doesn't have many through that location. So it would provide those components to that area that doesn't exist today. So
All right.
I won't go through all the breakdown, and that's why I asked if you had any questions instead of going through all the hardship criteria.
No, I don't have any questions about them, and I have reviewed them, and that additional information about the stormwater vault is helpful too.
Right.
So, yes, thank you.
Thank you.
And please sign in with the clerk, Mr. Campo. All right, is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
No, ma'am.
All right, and applicant, anything further? No. All right, thank you. This will close the hearing on variance 23-0220.
That concludes section F of the agenda. Takes us now to section G, signed variance requests. We have one case, item G1, application 23-0214. The applicant is 264 East 10th Street Incorporated, doing business as Walmart stores. The request is for a signed variance. Staff findings will be presented by Sam Ball.
Good morning, Sam Ball, Development Services. The applicant is requesting a sign variance to accommodate a facade renovation for an existing big box retail store. The property is located at 10327 South Big Bend Road in a zone plan development. Maximum building sign area is regulated through LDC section 70300A2A, which allows an aggregate sign area up to 1.25 square feet per lineal foot of building frontage facing a public street or parking lot, but in no event more than 200 square feet of aggregate sign area. The applicant is requesting an 87.1 foot increase to the maximum permitted sign area on the eastern front elevation of the building to allow a total of 287.1 square feet of sign area. That concludes my report.
All right. Thank you, Mr. Ball.
Thank you.
All right, applicant?
Good morning. I'm Mark Brenchley, address 3790 Beacon Ridge Way, Claremont, Florida. I'm representing the owner of the property and the Walmart store. May I present some geographical background to help us all orient to the site. North, the top of the map is Big Bend Road, running east and west. To the right, running north and south, is Highway 301. Here is the Walmart, located here. And here is Sam's.
Mr. Branchley, I just need to make sure you're on the microphone when
Yes.
you. Thank
So
you.
I pointed out the location for Walmart. As was mentioned, it's a PD. All these several lots were created in 2006. The Walmart is basically on a flag lot, has no direct frontage to either Big Bend or to 301, only the access driveways to it. The front of the building faces east toward 301, is 980 feet from the road, which is typically about 6 times larger than a typical setback that the sign code utilized in order to determine what is appropriate in terms of square footage of signs, and that's what was mentioned. The limit is 200 square feet. However, if this store, this Walmart store, was divided into 2 suites as a commercial retail center, because it has many different products, and obviously retail centers sell different products and have different names. If it were divided into 2, just for practical purposes, they could have 350 square feet if divided into 2. But this is 1, and of course the ordinance requires a maximum of 200 on any one frontage street. So Walmart has been, as was mentioned, all over the state of Florida and the Southeast. They're renovating all of their older stores, bringing them up to date and refreshing them. This is the case here. This store was built in 2015. At that time, the background was green. They are rebranding all of the Walmart stores throughout the South and Florida, and there's a blue background. They're changing. They're adding, in this case, a Riverview Market to make it more, let's say, oriented to the community. And that addition of the Riverview Village is the increase from the typical Walmart logo, which is the sunburst, and the Walmart name. And then they're adding the name of the area, Riverview Market sign. It's also important to note that the wall signs on this east-facing front elevation already exceed 200 square feet. And the wall signs facing north to Big Bend are being reduced from, I think, 180 down to 147. So they're going to conform to the code facing the street.
All right, Mr. Branchley, I did kind of have a question about that, so just wanted to clarify. So this variance is just for the sign on the building on the east-facing side, is that correct?
That is correct.
And it is replacing an existing sign, is that correct?
And adding the Riverview.
Riverview.
As well. Yeah.
And the existing sign on the building on the east-facing side, what do you know the size of that sign?
It's on the application.
Okay.
As it goes from 244 to 287, as was mentioned.
So the existing sign is 244?
Yes.
Okay. And then the signs on the building on the north side, Big Bend Road side, you're not seeking a variance for those, and they'll comply, is that correct?
That is correct.
Okay. All right.
Yeah,
and they're reducing,
reducing
in size from what's already there, is that
That's
correct?
And below the 150 square foot area.
Okay.
I think it's also important to note that rebranding is a big issue currently nationwide, and many national trades and retail stores are rebranding, modernizing, updating, refreshing their signage, and this is the case here at this location. Let's see. I think it's the last thing I wish to point out, this store being created or built in 2015, behind all of these other lots, as these lots have been developed, these frontal properties have developed buildings which increase the blockage, the visibility of the sign, and it already is 980 feet back from 301. So clearly is a hardship that has been compounded by additional stores, additional buildings, landscaping, and so forth. And so they have tried to fit the brand and appropriately to the size of the building and to the depth of the lot. Any questions?
No, that's all my questions. Thank you. That's fine. Just be sure and sign in with the clerk. Thank you. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, I don't hear anyone. Development Services, anything further?
No, ma'am.
All right, and applicant, anything further? All right, no. Thank you. That will close the hearing on variance 23-0214.
All right, this will take us to section H of the agenda, general variances. First case is item H1, application 22-1422. The applicant is Mike and Nicole Mesra, requesting a variance to fence requirements. Staff findings will be presented by Chris Grangillard.
Good morning.
Good morning.
Chris Grandlinard, Planner with Development Services. I'm here to present variance 22-1422. The applicant is requesting a variance for an existing fence and gate on 3 commonly owned parcels zoned RDC 12. Per LDC section 6.07.02.c.1.a, fences over 4 feet in height shall not be allowed within required front yards in residential districts except under certain circumstances that do not apply to this case. The applicant requests a 2-foot increase to the maximum permitted height to allow a 6-foot high fence and gate within the required front yards on the south side of the subject parcels along Palm River Road. Findings, the subject fence is the subject of a code enforcement case which has been placed in a case file for this application. Also, per section, LDC section 6.07.02.a.2 and 6.04.03.f, a maximum height of 2.5 feet is permitted for fences within motorist visibility triangles at the intersection of roadways and driveways. Approval of this variance, if granted, does not obviate the need to comply with this requirement and may necessitate the redesign or relocation of the subject fence. That concludes my staff report. I'm glad to answer any questions.
All right, thank you. I have no questions for you. All right, applicant?
Good morning, hearing officer.
Good morning.
I think that's better. Steve Michelini, representing the Mesras. With me is my daughter, Francesca Michelini. She's also been assisting with this request. First, let me start with the property was developed and built in 1985, and I have a picture of the fence that was at that location and was removed and then replaced. That's a photograph of the fence as it existed.
And Mr. Michelini, how high is that fence?
6 feet.
Okay.
It was a wooden fence, and it was in very poor condition. And I believe that the owner was told by someone in the county that it needed to be replaced because it was in poor condition.
And what year was it replaced?
That was 2 years ago.
Okay, so 2021, something like that?
Yes, ma'am.
Okay.
This is a photograph. This is a photograph of the fence in its current location. This is an aerial photograph of the. Can you see that, or move it?
Yes, sir.
Do I need to zoom in some, or?
No, I can see it fine. And do you know when this aerial photograph was made?
It was 2022.
Okay.
That came off of the property appraiser's webpage.
Mm-hmm.
This is another photograph of the subject fence. There we go. another photograph of the existing fence. If you'll notice on this next photograph, there's a grade differential between the fence and the top of the crown of the road, and it's approximately 18 inches. It varies from 18 inches to 2 feet in differential between the bottom of the fence and the crown of the road. The Mesra fence is on the right side. I'm sorry, on the left side. The opposing property is on the other side. It has a 6-foot fence as well.
What is that property, Mr. Mesra? I'm sorry, Mr.
Michelini.
Michelini.
I'm not sure. I didn't investigate that any
Oh,
further.
okay.
But it has a 6-foot fence as well.
Okay.
And the 6-foot fences, they extend from the railroad tracks, which is on the west side, all the way down to the next series of properties on both sides of Palm River Road. There's an exception in the code regarding the collector designation of Palm River Road, and that extends from 50th Street, which is to the west of the subject property here, and it extends all the way down to Maydell, which is down here. And there are exceptions in the code that allow for a higher fence.
And where would that be in the code?
I'm going to provide you with that.
All right.
You want me to, I'll just read it into the code and then I'll put it on the overhead.
All right, thank you.
It says here that, let me see, I highlighted that. This is under H, under the county code. It says walls and combinations of walls and beams, berms up to 8 feet in height may be erected in yards which abut arterial streets or collector streets as defined under Hillsborough County functional classification, provided no access is provided to the said arterial or collector and the fence is 2 1/2 feet or less in height within the site triangle described, and the staff referenced that as well. That's in 6.04.04. This is F. And
Oh, I'm sorry, I thought you said H.
it says F. Oh, it's in H, I'm sorry.
Okay,
The column heights are in F.
okay.
Also, the property, as I said, was developed in 1987 or 85. There's an exception in the code that says fences erected prior to April 15th in 1987 shall be granted non-conforming status. Now, I recognize fully that this is a replacement fence, and so the non-conformity probably has disappeared because they replaced the wood fence. However, we're asking for the hearing officer to recognize that exception.
I'm sorry, the non-conforming exception?
The non-conforming exception, they replaced the fence,
Okay.
but the property was developed and the fence erected in 1985.
Did the property owner go through the procedures to request a non-conforming?
No,
No, okay.
no,
Thank you.
they were not aware of doing that. And now I'm going to provide you with the Hillsborough County classification, where it says Palm River Road, 50th Street to Maydell Drive is designated as a collector. And I'll provide all this to you.
Thank you.
In addition to that, we also have a greenbelt designation that was provided, it was applied for and provided. They have rescue animals there as well as their own domestic animals. They have goats, donkeys, pigs, and various waterfowl and chickens. Anyway, there's also an exception here that's provided for. The fence regulation shall be the same for the residential districts except for provided in paragraph 2 below. Parcels with stables, bona fide agricultural operations as defined by the code, or phosphate mining. Fences up to 8 feet in height shall be allowed in any yard, although fences are required in the front yard shall not be more than 60% opaque. Now, we recognize that the opacity of this fence above the 4.5 feet is solid, so it is 100% opaque.
What section of the code were you reading from there, please?
The agricultural section, it's on figure 6.15, permitted fences in residential districts.
Okay.
And the general, the general requirements, there are exceptions, again, which indicate that no fence exceeding 2.5 feet in height shall be constructed within the visible triangle. In this case, none of these fences obstruct the visual triangle, nor do they obstruct traffic. I also have the property appraiser's webpage indicating that the property was developed and built in 1985. No. And the agricultural exception is also on there. So we believe that we've met at least the spirit of the code that deserves some exceptions. The hardship is not created by the homeowner. He's trying to protect and maintain the safety of the animals that are there. And as I said, he also accepts rescue animals from a variety of different sources. The grade differential does not create an additional hardship for any of the motoring public traveling along, as it's at least 18 inches below the crown of the road. It does vary in height, and some of it goes up a little bit higher than that, but it extends approximately 200 feet along the frontage of Palm River Road, and it goes all the way down to the railroad abutment that exists on the west side of the property. So we're respectfully requesting an exception to the code and be allowed to maintain the fence as it is. He innocently replaced the fence with a wooden fence that was dilapidated in its current condition and thought that he was doing the right thing. As the staff has pointed out, there is a code case pending on this, and at the time, we didn't have all of the other information available to us regarding the collector, regarding the agricultural designation, that perhaps we may not have been under code violation. However, we're now appealing to you as the hearing officer to recognize those exceptions and provide us with an approval.
Okay. Would you please, just a couple of observations about the property and questions related to that. Looking at it on the aerial view from the property appraiser's website, it's on the river, I guess, and it appears there's a residential structure or a home toward the north near the river, and a tennis court, and then a structure or two structures closer to Palm River Road. So where exactly are the animals maintained on this property?
One of those is a barn.
Okay.
And the other, that's their home that exists further down in the tennis court, a little bit further to the north. They directly abut the, I think it's the Buddhist temple, immediately to their east. They've had no one who's complained or had any objections, but they have experienced animals escaping, and that's why they put the higher fence up.
Okay, and so the structure closest to the river, is that their home?
Yes.
Okay, and then the tennis court is a little bit south of there, and so the structures up closer to Palm River Road, you said one of those is a barn. Is that on the same lot as their home?
There are 3 parcels that they all own collectively. I've shown you the main ones that were cited in this in the code case. It was kind of hard to combine all of them, but the barns are closer up to Palm River Road.
Okay, I see 2 parcels. I see one smaller one right on Palm River Road, and then one larger one on Palm River Road that extends all the way to the river. That's one parcel, and there's two folio numbers listed on the application. So is that all of the subject property, or is there another folio?
Hold on. You'll have to answer that. Answer.
Francesca Michelini, 10925 Tailfeather Court, Tampa, Florida. The third parcel is not in question today for that situation. We had to bring it up because of the fact that there was a combined folio previously, and that came to question through the application process. But these 2 main folio numbers are the ones that are the focus of this application because of the fact that the fence fronts those properties.
Okay, and, well, I guess it was brought up that there were 3 parcels. Where is the third one? Is it adjacent? Is it?
It's adjacent. We had to include it as part of the notice, and that was one of the issues that we were presented with staff. I mean, Mr. Hisney can
Yes.
respond to that.
Excuse me here for clarification of the record, all right? There actually are, to my knowledge and understanding, there's 3 parcels involved in it. If he can show his aerial had the red outline, yeah, the right, what you had on the top, the one that you're just using, the one you're just using, that one, right? Okay, my understanding is the notch out that's on the lower left-hand corner is actually the 3rd parcel, and that this fence that we're dealing with actually extends in front of that notch out. Is that correct?
That is correct, but the main parcel with the red outline is actually 2
Correct,
parcels.
right. So the fence,
That's my question.
right. so the-
Okay, I'm sorry.
The large
yeah.
parcel with the star on it in the red outline is listed as 1 folio number. Are we referring to that as 2 parcels today?
Yes, and it
Yes.
is literally two lots that, putting them under 1 folio doesn't erase the lot lines. So if you look on, in your backup, the revised survey that's included in your backup shows all 3 parcels. You have 2 parcels that are fronting the road, and you have a 3rd one that is a large flag lot. And the
Okay.
fence extends in front of all 3 of the parcels. And one of the reasons this case had to be continued was to update the application to include the 3rd parcel, which is that notch out on their graphic, to bring in the deed and to update the folio numbers and the notice requirements to include that 3rd parcel.
Okay.
And in fact, the fence extends in front of all 3 of these parcels, correct?
Yes.
Yes, there we are.
All right. It's not a platted property that I can see. I
It's
don't see a plat.
unplatted.
Okay, it's unplatted. And I see 2 folios. And this is where I'm just not understanding why we're calling it 3 parcels. But the real question goes to what property is involved. And if it's just that large parcel and what Mr. Hisney is referring to as the notched out parcel, those 2 folio numbers, that's the only property involved, correct?
Yes, it's
All
only
right.
the frontage on Palm River Road.
Okay.
And the other,
Of those
when I
2.
was calling it a parcel because it was separated by a folio number, but it's the rear has a different folio number than the frontage, the 2 frontage properties.
Okay, don't see that in the record, but okay, that's fine. Then my earlier question was where on these properties, the subject property as a whole, where are the animals kept?
They have corrals and they also have barns that are on the side that's closest to Palm River Road.
Are they allowed free range in that area of the property closest to Palm River Road?
They are corralled, so they don't have a complete free rein, but they do have limited area, but it's fairly large.
Okay.
It's not free roaming in the entire property.
How is it that, please explain, if the animals are kept in corrals, why is a higher fence needed to protect the animals to keep them from getting out?
The goats climb quite a bit. So the goats and the donkeys, both of them can get out and climb over the small wooden fences that are used to keep them in a designated area, ideally, but they can climb that. And so the fence is a secondary barrier to preventing them from going onto the street or other properties.
How high are the fences that they're kept in on the property?
4.5.
Yeah.
They're about approximately 4.5 feet high.
Okay. So why would the solution be to put a higher fence with a variance along the frontage of the road rather than making a higher fence barrier in their corrals?
They have had some experience with vandalism as well as individuals trying to steal some of the animals. And since they're also a rescue area for animals from the Humane Society, then they have individuals who like to come and try to retrieve animals, what they consider to be their animals, but they've been seized for whatever reason.
So is it your testimony then the higher fence is necessary to keep people out of the property?
It's for both, to keep the animals in and to keep other people out, except those that are authorized inside. They have hired, in one of the structures, they have a full-time property caretaker for the animals. That also serves as security and a guard.
Okay. All right. I think that's all my questions, Mr. Michelini.
I'm sorry about the graphic. I mean, it was the best we could get on the property appraiser's webpage, but
It's okay.
as Mr. Hisney pointed out, the frontage, all of those properties are included in the request.
All right, thank you. Thanks for clarifying that. I appreciate it.
Thank you very much.
Yes, sir. Be sure to sign in with the clerk. But both of you, please sign in with the clerk.
We signed early.
You did. Thank you. Thank you. All right, is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development services. Anything further? And might you also speak to those exceptions that were brought up? Thank you.
Ma'am. All right, so first of all, just again, to clarify the record, when you look at the site plan, the survey that's in your backup, you clearly see the 3 lots that are involved in this, right? These are 3 separate lots with 3 separate deeds, 2 of which are under one folio, and the 3rd one is under a separate. So that's why you only see 2 folios, because one folio covers 2 parcels. But that doesn't obviate the fact that they are indeed separate parcels with separate deeds. So there are 3 parcels involved here for the variance. Now, going through some of the comments of Mr. Michelini's regarding possible nonconforming status of the fence, the code does provide that a fence erected before April 15th, 1987 can be granted nonconforming status, but like most other nonconformities in the county, you can't replace it. So it may be relevant, the fact that there was nothing was submitted with regards to confirm that it was done before 87. I'm not doubting what he's saying. But even if it had been, you would not be able to replace it without a variance. All right.
Okay.
With regards to the other comment regarding an allowance in the code for when you have properties fronting arterial or collector streets, the code does provide for that to allow for a fence up to 8 feet in height. However, it also says that provided that no access is provided to said arterial or collector directly to the lots. And in this case, all 3 of the properties that are involved in this have direct access to arterial or collector. So that exception would allow an 8-foot high wall does not apply in this case and doesn't obviate a need for the variance. And then finally, where he made reference to the part of the code that talks about fences where involved with an agricultural activity, that provision is actually found in the part of the fence regulations that deal with fences in agricultural zoning districts. This property is residentially zoned, so that provision would not apply here to begin with, because it's the wrong zoning district. And as Mr. Michelini pointed out, that provision also requires that above a height of 4 feet, the fence could not be more than 60% opaque. So again, it does not obviate the need for the variance. So just to make clear that a variance is indeed required for this fence. And then I'm available for any other questions you may have.
All right, thank you. I think that covers it. All right, applicant, anything further?
No, hearing officer, just that we concur that once he replaced that non-conforming fence, it lost its non-conformity. My discussion regarding that was there should be some consideration for that in addition to the other factors that we presented. So we appreciate your consideration and respectfully request your approval. Thank you.
All right, thank you. I understand. Thank you. All right, this closes the hearing on variance 22-1422.
Okay, that takes us to item H2, variance application 23-0126. The applicant is James Hatton, requesting a variance for accessory dwelling requirements. Staff findings will be presented by Chris Grangillard.
Good morning again. We're to present variance 23-0126. The applicant is requesting a variance to accommodate a proposed accessory dwelling on property zoned AR. The variance per LDC section 6.11.02.c, a maximum of 900 square feet of living space is permitted in an accessory dwelling, except that a variance to increase this amount may be requested provided the residential lot is at least 14,520 square feet in size, and the living space proposed for the accessory dwelling does not exceed 1,200 square feet or 25% of the living space in the principal dwelling on the lot, whichever is less. The applicant requests a 300 square foot increase to the maximum amount of living space allowed in an accessory dwelling to allow 1,200 square feet of living space. Findings: the proposed accessory dwelling will be located on a 11.5 acre parcel zoned AR. The property is presently pasture land and does not contain a dwelling unit as proposed by the applicant. The accessory dwelling will be located above horse stables in a detached two-story structure. The applicant intends to construct a primary single-family dwelling on the property concurrent with or shortly after construction of the subject accessory dwelling. The applicant has been advised the primary dwelling must have at least 4,800 square feet of living space pursuant to LDC section 6.11.02.c. when constructed in order for the requested variance, if approved to be effective. The applicant has advised staff the primary dwelling will meet this requirement. Conceptual floor plans submitted by the applicant show the proposed accessory dwelling will be centrally located on the second floor of the detached structure with attached truss attic space above the stable area. Staff has advised the applicant the attic spaces cannot have flooring and must be accessed solely through the stable area. Otherwise, those spaces will constitute storage area, which per LDC section 6.11.02.c contribute to living space calculations for the accessory dwelling that consequently will exceed the 1,200 square foot maximum which may be considered. Final determination on the amount of living space in the accessory dwelling will be made at the building permit review. That concludes my report. Have any questions? Okay, thank you.
No questions. Thank you. All right, applicant.
Hi, my name is James Hatton. I'm the property owner at 17896 Boy Scout Road, Odessa, Florida. And I am proposing a variance to increase the living space above the barn, going from 900 square feet to a maximum of 1,200. This is the property aerial view. This is where the primary residence is going to exist, and this is where the barn is going to exist. The barn will be a two-story structure. Primary first floor is going to be all stables. Very hard to see, but there's 9 stables. Along with an equipment room and a feed room for storage. The proposed living spaces above has a single bedroom, bathroom, and a common living space. The variance is predominantly going to only extend one exterior wall to give the common space just a little bit more room, allowing for the stairs to enter and access into the bedroom.
Mr. Hatton, could I see the drawing just under this one, please? And point to where the living space will be.
So this is the first floor. So there's no living space on the first floor.
Right, but where's it going to be in relation to that on the second floor?
So the living space will be up here,
Oh, okay,
okay? These stairs
I see.
enter to the living space.
Okay.
So the living space is cut off right around in this general area.
Okay, thank you.
There is going to be 3 access points to get to the attic space for future maintenance. I've got one over in the feed room. I've got one in the back little corridor over here, and then I've got another one to the other side of the building. They would be just a standard pull-down ladder-type access. All of the framing up in the living spaces will be standard trusses. So the cross bracing will allow or prevent any future building. It would obviously compromise the structure. So.
Okay. All right, and so the barn is not built yet, it's planned, and these are the plans for it, and your residence, when will that be built?
They are going to coexist. The hope is to permit at the same time. If anything, there might be a 30-day, 60-day difference between the 2 buildings.
Okay. And then in the staff report, you're aware that this single-family home, the residence has to be a certain minimum size in order to get this size of an accessory dwelling.
That's correct.
And you'll comply with that?
The home is proposed to be 5,300 square feet.
Okay. All right. Anything further?
No.
Okay. Give me just 1 second to see if I have any questions about your variance review, your variance response. So I guess just in general, the variance response has to show a hardship, and in this case, the purpose for this living space. Can you explain that a little bit?
Yes, the living space is going to be the primary residence of the property manager, the barn manager per se. The barn is going to be an active barn. Its intended use is to board female horses that are pregnant, and the appropriate person living in the space, it acts as an income source for the individual to not have to pay rent, but it also allows 24-hour care to the horses, because obviously, you know, horses can be born in the middle of the night or could be born during the middle of the day. So this allows primary care for the animals.
Okay. All right, thank you for that. I don't have any further questions.
Great.
Thanks. And, all right, is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. Development Services, anything further?
No, ma'am.
Okay. And applicant, anything further? No, thank you. All right, this will close the hearing on variance 23-0126.
Our next case is item H3, variance application 23-0200. Applicant is Thomas and Casey Marvin. The request is for a variance to fence requirement. Staff findings will be presented by Chris Grangillard.
Hello again. Here to present application variance 23-0200. The applicant is requesting a height variance for a portion of an existing wall on property zoned ASC 1. Per LDC section 6.07.02.c.1.f, the maximum average height of any fence or wall shall be 6 feet, except under certain circumstances do not apply in this case. The applicant requests a 1 foot 4 inch increase to the maximum permitted height to allow a 7 foot 4 inch wall within a portion of the required side yard of the west side of the property, as shown on the site plan submitted by the applicant in the record. Findings, during staff review, it was discovered that existing walls on both sides of the entranceway and the gate across the driveway appear to be more than 6 feet in height. The applicant advised staff that they do not want to add these additional portions of the fence to this variance application. That concludes my staff report. Any questions, let me know.
No questions for you, thank you.
Thank you.
All right, applicant?
Oh, thank you. Thank you. Madam Hearing Officer, my name is Todd Pressman, 400 2nd Avenue South, number 451, St. Petersburg. I'm here today with Mr. and Mrs. Marvin. They're in the front row here, and they'll speak for a few minutes. Do you have the PowerPoint up?
Yes.
Okay, thank you. Madam Hearing Officer, we are here today for one reason only. The Marvins didn't decide one day just to wantonly put up a little higher section of wall. They had no reason nor any need to put up a higher wall. We're only here because the abutting neighbor has established and is continuing to operate an intensive, loud, terribly impacting batting cage apparatus that is continued throughout the day and evening, 7 days a week, of which the noise and smashing of baseballs is far beyond any kind of neighborhood disruption, beyond any kind of neighborhood disturbance, and beyond any kind, in our opinion, of any appropriate use next to a single-family home in a single-family area. That's why we're here today. So this is a portion of a wall height to 7 feet 4 inches, where 6 feet is permitted. We're located in the Bloomingdale area. This is a survey that shows the portion of the wall that has been increased to 7 feet 4 inches. And on an aerial, you'll see the variance home site, which is the Marvin's home, residential home, and the batting cage is highlighted next door where the neighbor is. You can see it's a very close location to the property line. This is just an approximation just to show you and orient you to the area of the wall height that's already in place. So looking at the ground level, the neighbor's home is what's in the center. You can see with the up arrow where that little jog of increase is in the existing wall, and you can see where the batting cage is located directly next to the property line. This is the aerial view again. This is on the Marvin's property, looking at the batting cage. And this is important. This is the orientation of the Marvin home, as you can see with the batting cage on the near the property line pointed out to you there. So they have the residential home and their pool and backyard areas directly behind the home that you see there. We have the measurement of 10 foot 4 inches, side setback, 11 foot rear setback. The ASC 1 setbacks are much more extensive. I'm going to digress for a moment, if I may. Accessory uses under 2.0, 2.04, and this is important, that accessory uses are in nature and extent customarily incidental and subordinate to the principal use. The hearing officer, you've been handling cases for a long time. You handle a lot of cases on your own. I don't think you've ever seen, nor have I ever seen, a batting cage next door to a residential home. I did find one notion or one note of batting cages which are only relegated to golf driving ranges, which gives you perspective as to where these uses are permissible or not. But that's important in terms of the impacts and the noise and the negative detriment this has caused onto the Marvins. As well, accessory structures are a conditional use in the ASC1.
They're certainly not permitted as a home-based business, not permitted as a school, not permitted as a recreation use, general outdoor. So again, I digress. But in that regard, as I looked at setbacks, and as I understand it, which is not critical to the variance case, but that the accessory uses or accessory structures are to be behind the primary use unless it is abutting said required side yard, which places this use way in front of, well, in front of the Marvin home. But here's a track of variance beyond what I've spoken already. As you notice along Bloomingdale Avenue, the lots are very regimented, very similar in scale and size and how they run along Bloomingdale. But then we get to the Marvin home, and we have a lot that is much larger and has an extremely unique and singular configuration. And what that does is it wraps around the home next door, upon which, at the worst point possible, this batting cage has been erected and used. So the subject site is the Marvin site, and I've noted the property which is the cage site. And when you look at it closer, you can see that the unusual shape of the lot as it wraps around the neighbor's lot is unusual, is singular, and forces, because of the use by the neighbor, forces the impacts of noise onto the Marvin property, both interior and exterior. So looking at variance criteria, I think I've made very clear what the alleged hardship or practical difficulty is. It is unique and singular in regards to the subject property. It does deprive the applicant of rights commonly enjoyed by properties all over Hillsborough County, which is peace and quiet and an acceptable, appropriate use in a residential area. It will, and note, it will not substantially interfere with or injure the rights of others. Now, what the Marvins have done is they have had many discussions with the neighbor to try and alleviate this. They have not called code enforcement. We're looking for other elements. So Mr. Marvin moved ahead and tried raising the wall 1 foot 4 inches, which did have a pretty good significant effect at reducing the noise. So that he did move forward that, and that would relieve the situation to a point, which is why we're here today. It is in harmony with and serves the general intent of the purpose of the LDC. The code does allow 8-foot fences in unusual circumstances, particularly through PDs, and those are recognized, and certainly are recognized in areas or properties that have sensitivities or properties that have difficulties. Does not result in a legal act from the actions of the applicant. The lot configurations are certainly not the result of the applicant and how they affect this particular site, but I would also add in, I think what's proposed before you is de minimis, in my opinion, and additionally, served to meet the standards of a typical residential neighborhood in the best way possible to try and move forward in a peaceful manner between neighbors. And that's something we want you to consider, which is the last item about substantial justice. This is a dispute between neighbors. We would like everyone to be able to move forward. This allows everyone to move forward in a very peaceful way, and the Marvins can retain their home in a peaceful manner. So with that, we appreciate your attention. We appreciate your consideration. I do want to play for you a couple of videos that are in the record. These are videos with audio that captured the sound and use of the property next door. The volume was way down on that. There have been discussions with the neighbor. I have had some text discussions with the neighbor. It's my understanding, I don't know if he's here today, you can clarify or discuss that with him. My understanding is that he's been involved in baseball as a coach at a high school and a longtime presence. And this is a batting cage that he coaches or provides lessons or brings people there to have batting practice in some manner. That I don't have certainty with. I don't have a factual element, but my understanding from speaking with him and looking online, that was my my summary and guess. So with that, again, I do want to place emphasis that this is an issue between neighbors. We are hoping that this is a way forward that can be a peaceful end to a long-term resolution, and we appreciate your help and consideration.
So,
Mr. Marvin would like to have a few comments.
And I want to hear from Mr. Marvin, but I have some questions for you, so please.
Yes, sir. Yes, ma'am.
Thank you. You, and I understand why you brought up the accessory use, and I understand that property is not before me today. This property is the subject property that belongs to the Marvins and their request for a variance. But it seemed like in your testimony, you are saying that the accessory use, this batting cage, is probably not something that would be allowed there under the code. Is that correct?
Well, as a zoning consultant, not a lawyer, that would be my opinion.
And so what this variance then would do would allow or help allow the peace and address the hardship of the Marvins while also allowing an accessory use next door that probably isn't allowed under the code.
I would say with you, with all due respect, that the approval of the variance is really indirectly associated with the use next door. So our sole interest is to diminish the noise, and whether the use next door will continue or not, it may become apparent at this point that code enforcement or other elements will come out and take another look.
Well, and I misspoke. I don't mean that this variance will allow that use. It won't. But it seems that the appropriate response of the neighbor, of the applicant, would be to report this if it isn't an allowed use or it's disturbing his peace. And so your testimony was that he hasn't reported this.
To my understanding, he has reported it. However, it is my understanding, which is not 100% clear, and the Marvins can clarify this or bring further light to it, that there was a code enforcement visit that did not result in a citation, from what I understand. However, reviewing the situation, again, in my opinion, I do believe that the use is inappropriate and not proper, and the location is also improper. I believe that accessory structures and uses are kind of bouncing around the code quite a bit, and I think if you dig deeper, not think, but when you dig deeper, certainly the table of uses I showed, the use itself, I don't think any of those are permissible. But again, that's my opinion, but I haven't filed code enforcement. What we're trying to do, as you clearly understand, is try and move this forward in the most peaceful manner. And I think when you get down to this level between two neighborhood properties, I would say to you with great respect and liberty, I think there's a different way to look at these things when we're looking at a very small increase to try and alleviate what's a very unfortunate situation.
Okay. And this is not a, I mean, obviously it's a structure, it's a building there, some kind of a building that this batting is going on in. It's not actually, I've seen them that they're basically nets, but this is inside a structure of some kind.
That is correct.
Is the sound coming from the actual bat hitting the ball, or is the
Yes.
ball hitting the building making a noise?
Certainly from the sound and from what I understand the use is, it is hitting a baseball. I don't know where the ball goes or how that is alleviated.
Okay. How would the volume of this compare to, say, a lawnmower?
My personal opinion is a lawnmower, I think there's two critical elements in terms of frequency and time. A lawnmower is going to come out and mow your lawn. It's a consistent noise that you sort of after a while, your mind sort of dissipates it. As I understand it, this is 7 days a week, morning, afternoon, evening, as I understand. You'll have to confirm that with the Marvins, which is intermittent. So you get the smashing for whatever, I don't know, 20 minutes, half hour, hour, and then it stops, and you kind of forget about it. Then it starts up again, goes throughout the day. So it becomes a continual annoyance. Maybe this is not a great explanation, but at my condo this morning, our smoke alarm was chirping. And it would chirp, and you're like, oh, I got to get a battery for that. And you forget about it, and then 10 minutes later, chirping again. So it's an all-day disturbance, annoyance that just destroys the peace and quiet of the home.
Okay. I understand. Thank you.
Thank you.
Thanks for addressing those questions. And Mr. Marvin, please, I would like to hear from the property owners. And I know we're running out of time here, so I've been asking questions. I'd like to grant another 5 minutes or so on the time.
Hello.
And state your name and address, please.
My name is Thomas Marvin. I live at 3710 Bloomingdale Avenue. This is my wife, Casey Marvin. I'm going to answer the questions that you asked Todd to try and start off so I don't forget.
Thank you. And when exactly did, or when about did this start also, please?
It started in 2020.
Okay.
Right, in January, February, roughly.
Mm-hmm.
Okay. Yeah, okay. I've never called code enforcement.
Okay.
It had showed up, I believe my neighbor, Sal, which he'll come up next, and he'll tell you whether I don't know exactly what happened or how it happened, but they asked me questions. Why did you do what you did? A gentleman named Matthew Kent, which I think he's a Hillsborough County inspector, came out as well, actually before code enforcement. And I explained to him the reason why I built the wall, the height that I did. Kind of calculated, Mr. Kent understood, and then code enforcement came out right after him. So I just don't want to waste your time. I have this long list, but okay.
And I can address the
Okay,
hardship as far as.
before you speak, please state your name and address also, please.
My name is Casey Marvin. I live at 3710 Bloomingdale Avenue, 33596.
And I need you in the microphone so y'all could swap places or
Sure,
whatever.
sure.
Thank you.
I just wanted to address what Todd was saying as the intermittent. I work from home. I'm a teacher with Florida Virtual School. So I teach online at random times. I'm helping students. I'm Monday through Friday, 8 to 8. And I just never know when it's going to happen. You know, I could be in a Zoom call and have my window open. I could be teaching my science class outside. And, you know, the metal bat hitting a ball is kind of disruptive for fifth graders. So that's kind of the reason that I complained to my husband and said, do something about this, please, because I'm working from home and trying to make a living. So, you know, I've kind of adjusted some things for myself, but I don't think that I should have to do that when it's my work hours. So just to address that hardship, what he was talking about, intermittent. That's what we had discussed with Todd.
What is the response of your neighbor, the one with the batting cage?
Okay. Basically, so I have to go into it. So.
And again, please make sure you're on the mic.
Relatively, it's been, my neighborhood's great. Sal was a great guy. When we first moved in, everything's great. He's still a good guy. But he's just not, he's not conforming to what I feel is right. So I even let him, he had asked me at my 40th birthday if he could put a shed on the property. And can I drive on your property to do it? I said, sure, a storage shed. I'm thinking storage shed, right? You can go on my property, pull the fence down, put it on there. No problem. As soon as I saw those huge A-frames going up, I'm in construction. I know this is going to be a building, not a shed for storage. And I asked him what the intent of the building was. And it was to have a batting cage there. And I said, please don't do that. I said, I didn't understand when you said shed. I was assuming shed for storage, right? Or workshop or something like that. So basically he told me I have to do what I have to do to make a living, in so many words. I don't know exactly because I don't have it quoted. It's been years. But, and I kindly said to him, I said, listen, then I'm going to have to do what I have to do to,
Disrupts our family.
to get the right height. It's all calculated. I got at the top of her window to his batting cage, ran a string to calculate it so the top of the noise hits right at the top of my window header, So it goes off that and it bounces off. It does, but it clears her window in her office. So
But it still is very disruptive during, we could be having a pool party for our daughter on the weekends. That's the thing. You can never give me a set time. So planning around that, I guess, it's just kind of very.
It's difficult.
It's not convenient for our family life. We have 2 young girls, and they like to have friends over, and hearing a metal bat hit a ball at whatever, who knows. It doesn't go past 10 o'clock that I know of because I'm asleep, and my room is on the opposite side. But, it's just, I don't know. I know when my gardener's coming, when my lawnmower guy comes, he comes every Saturday morning at 7 o'clock or 8 o'clock, not 7 o'clock, 10 o'clock, I don't know. But, that's.
Okay. Ms. Marvin, let me ask you this then. And the increase in your wall, it is a wall, right, or a fence?
I call it a fence, but it's a wall.
It's a wall.
Yeah.
The increase in your wall, is it masonry?
Yes, ma'am.
That increased height is masonry?
Yes.
Does it help alleviate, or does it alleviate the sound disturbance?
Kind of. I can still hear it, and I can, it alleviates some, yes. Does it still exist? Yes. So it has some, yes, ma'am.
Okay.
One more, can I speak one last time?
Yes, please.
We've discussed this many times in the evening, and we're willing to have him, because I've never taken a man's living away. If that's what he does for a living, and he needs to make money or train his kids to be better athletes, or whatever he's got to do, I don't care, but I took it upon myself to fix the problem. I have not charged him for anything, asked him for anything. I'm just trying to fix a problem. And I've solved it for my wife, where she still is not happy about it, but that noise, like I said, it clips right at the top of the window, it bounces off. She doesn't hear it when she's in her office. So.
Okay.
But when I'm outside, I do.
Or outside, well, we can
Teaching
adjust science, we could come up with something good about the noise, that's fine. But we're willing to, he can do what he'd like to do, and we'll do what we did with, if you will allow, please, this extra 16 inches. I would greatly appreciate it.
In the corner.
All right, I understand. Thank you. I have no more questions. Did you have
Sorry
anything you
to
want
take
to?
up the time.
No, that's fine. No more testimony you wish to add? If you do, please
No,
go
ma'am.
ahead.
No,
Okay.
thanks.
And I need both of you to sign in with the clerk. Thank you very much. All right, we'll go to, is there anyone here or online who wishes to speak in support of this request? All right, is there anyone here or online who wishes to speak in opposition to this request?
My name is Sal Giardina. I'm a resident of 3630 Bloomingdale Avenue. I just want to start, how did we get here and where we're at? I wish I train kids 7 days a week. I probably do it 6 to 10 hours a week max at night. It goes, I usually, because I have baseball practice I coach at a local high school at Sefton Christian. I have practice until 6 o'clock, so I usually don't get started with, if I'm going to train any of my boys, it's going to be at 10:30, or I'm going to be at 6:30 at night. Never goes past 9 o'clock. So the hours, there's a little confusion there on how long I do it. Again, I don't do it on weekends either, so I don't know where that came from because I'm always coaching on weekends. But how this all started, I just want to go over some quick things.
And Mr. Giardina, please keep in mind that the question before me is not, and first of all.
About the wall.
First of all, yes, you're the neighbor with the batting cage, is that correct? Okay.
Yes, I am.
So your batting cage is not before me today, it's the height of the wall.
Right, and I'm
Okay.
just trying to get there. So,
All right, thank you.
You know, when here is, because you asked the question before, that's the side of the building. So you can see what the building looks like. Okay, and this is that's the front of the building. That's facing my garage, and you can see the wall behind it. So just to, what my problem with the wall, okay, when I put the building up and he came over to the fence, I said, can you move that in your backyard? You can't move a building like that. And we talked, I was going to put a batting cage back there and just put a carport over the top just to cover it so when it rained. But I said, you know what? Let me try to put walls on it to keep the sound down because it would have been a lot louder and a lot more disruptive if I didn't put walls on it. So I put the walls on the building. So how we got to the point when he put the wall up, I'm actually not upset about the wall. What I'm upset about is this. Stuff like this. When they put the wall up, there was a lot of things that did not take consideration of my property.
Okay, I cannot see your picture, so I need that overhead turned on. Thank you. Okay, now I can see your picture.
For example,
All right.
there's a couple things that, there was no consideration to my property. When you put a fence up, you usually put the nice side out. Now, they got a beautiful property. They do unbelievable job on keeping that property up. Their side of the wall is beautiful. My side of the wall was done shoddy when they put the wall up. And like, for an example here, there was a tree cut down. As you can see, the wall veers out. That tree was on the property line, pretty much his tree. He cut the top of the tree off, left the stump there, and the side, because there was a tree on the other side of that he couldn't put the footer in, so he went back a foot, came around, came back in, and then continued the wall. But left that stump there in my backyard.
Okay, well, just let's stop for a minute. This is on your side of the wall, correct?
It's on my side of the wall.
Okay, and this is the part of the wall that is not the addition, not the height addition, is that correct?
It is where that cuts out, that's where the addition, the height stops. Okay?
But what's before me today is the height of the wall.
Well, again, this is what I'm trying to stay out here, is the work that was done on my side of the property. That's what I'm upset about the wall. That's the reason why. If you want to keep it at 8 feet or 7 feet 4 inches, I don't have a problem with that. I'm not fighting the size of the wall. I'm fighting the shoddy stuff that was done on my side that in some spots I feel is unsafe because, like, the mortar has holes in it.
Okay, then just let me ask you this question,
Yes.
please. Do you have any opposition to the additional height of the wall?
I have zero opposition to that.
Okay, thank you.
I'm trying to be a good neighbor here, and I want to work with them, but I'm asking them if they could do the work. If you're going to put the wall up, and it's been 3 years, and you're going to put the wall up, let's, take care of my side of the fence. Like, for example, okay, I'll just show you another piece. There's all the mortar sticking out of my wall. They wiped it in some areas when they put the cinder block down. In other areas, the mortar came out and they didn't wipe it. So now I'm just asking, I would love, before you approved the height, that the job was done right. And he took care of his neighbor and cleaned that stuff up. I'm not here to fight the size of the wall. They want to put a big wall up. My wife doesn't like it. She feels like she's in a prison when she goes outside because the wall's so tall. But so what? It gives me privacy. They have a lot of parties in their backyard. They do a lot of stuff. It gives me privacy. I'm okay with the size of the wall. I'm just asking for the board here to have this other stuff fixed before you approve this size, the height of the wall. That's all I'm asking.
Okay.
Again, I'm not, like I said, if the wall makes them comfortable and it helps them out, I'm okay with the size of the wall. But what I'm not okay with is everything else that went along with the wall.
All right.
All right? And when code enforcement did come out, I was going to call code enforcement on the wall, called 4 times, canceled 3, because I didn't want to be that neighbor. The 4th time I called them out there because my bottom of my shed was getting rotted out because of a drainage problem. When they put the wall up, all my water drained to a cow pasture that I had nowhere for the water to go. He did put a drain in 8 inches above my ground. So the water had to get 8 inches deep before it started to drain, which was rotting out the bottom of my other shed that I have in my backyard.
All right. The only question before me today, sir, is the height of the wall.
And again, all I'm asking you guys to take consideration that stump that he did, all the mortar, and there's a big piece of that when they filled this wall with cement, it just was done shoddy.
Okay.
All right?
Thank you, sir.
Thank you very much.
All right. Is there anyone else who wishes to speak in opposition to this application? Don't hear anyone. Development Services, anything further?
Not unless you have questions.
I don't believe I have any questions. A lot of things were raised, but regarding the height of the wall specifically, I think I don't have any questions for you. Thank you. All right, applicant, do you have anything further you wish to add?
I do, and I would like to ask you procedure-wise, I would like to know and understand if permissible, sure, and if allowable, I would like to ask a question of the neighbor, is if he is receiving funds or is this a business? We'd like to have a little clarification as to what the activity is, whether it's just coaching a few people or coaching these people on his behalf voluntarily, or if it is a business that fees are charged for some people.
All right, so I think what you're asking, Mr. Pressman, is to cross-examine or to direct examine the opposition testimony, is that correct?
Just on that one question, yes.
And I don't think that question is relevant to the height of the wall. And the only question before me today is a variance for the height of the wall. If you have, I mean, I don't see how that's relevant to this question. So
I understand, and I would say to you, with all due respect, it's a tangent to this question, because one of the issues that we are contending with is if this is a home-based business of which would change the way zoning looks at the use. So I would ask for the greatest liberty if we could ask that one question so we could have that clarity.
all right, I might ask Ms. Dorman for assistance on the procedure here.
Madam Hearing Officer, I think it's within your purview to determine whether or not the question is relevant, and I think you already spoke to that.
All right, thank you. Mr. Pressman, you have about 3 minutes left.
Yes.
And if you have other testimony you wish to give, please do that. If you can question the neighbor within that 3 minutes, go ahead, but it may be completely irrelevant evidence that I'll disregard.
I understand. 2 quick points. One is on the photo attached. When the wall is installed, you see there's an area above that's clean. You see a fence there. According to Mr. Marvin, when he erected the fence, he came through and cleaned the top of the wall. The fence was installed at the time. He could not clean the lower area where the fence was installed. Now, I do have a question. How do you want me to ask the question? Just ask the question to you or to the neighbor?
We'll have the neighbor come up, and both of you need to be on the microphone. You have about 2 minutes left, so need to make it fast.
Thank you, sir. We appreciate you being here today. Respect you here. I would just like to ask if you receive any monies or any fees of any kind by any of the persons that you coach.
By all the people I train, I do get paid for at the time that I train them.
All right, and state your name on the record too, please.
My
sir.
name is Sal Giardina.
Thank you, sir. Thank you, hearing officer. Appreciate the liberty on that.
Thank you, Mr. Pressman. Is that all? Did you have anything further?
Yes, we just need your help here. Thank you.
All right, thank you. That concludes the hearing on variance 23-0200.
Our next case is item H4, application 23-0204. Applicant is Tammy Askew, requesting a variance to fence requirements, lot development standards, and accessory structure requirements. Staff findings will be presented by Tanya Chapella.
Good morning, Tanya Chapella, Development Services. The applicant is requesting variances for a proposed aluminum fence, an existing single-family home, and a detached garage on property zone ASC 1. The first variance is for a single-family home. A minimum side yard setback of 15 feet is required in the ASC 1 district. The applicant requests a 1.3-foot reduction to the required side yard setback to allow a side setback of 13.7 feet from the easterly property line. The second variance is for a detached garage. Accessory structure shall not exceed 15 feet in height, except where the accessory structure meets the primary structure setback of the district. The applicant states the subject detached garage is more than 15 feet in height. a minimum side yard setback of 15 feet and minimum rear yard setback of 50 feet is required in the ASC 1 district. The applicant requests a 4.1 foot reduction to the required side yard setback to allow a side setback of 10.9 feet from the easterly property line, and a 24.5 foot reduction to the required rear yard setback to allow a rear setback of 25.5 feet from the northerly property line. The third and last variance is for a proposed fence. Per the Land Development Code, Section 60702C2, fences in agricultural districts shall be regulated in the same manner as fences in residential districts, except under certain circumstances that do not apply to this case. Per the Land Development Code, Section 60702C2, C1, a maximum height of 4 feet is permitted for fences in required front yards, except under certain circumstances that do not apply to this case. The applicant requests a 1 foot increase to the maximum permitted height to allow a height of 5 feet for a proposed fence that will be set back 14 feet from the front property line. This concludes my presentation. I'd be glad to answer your questions. Thank you.
Thank you. Don't have any questions for you. All right, applicant?
Good morning. I'm Tammy Askew, 12509 Bronco Drive, Tampa, Florida, 33626. So we're a military family. We've just moved here about 6 months ago, and we have a large Bernedoodle, 85-pound dog, and we wanted to build a fence in the front yard high enough that he wouldn't jump over the fence. So we did the variance, and during the variance talking, we found out that the 2 structures that were already there when we bought the property were not in code, I guess. So we're trying to make that right, and that's the detached garage in the back and the garage that's attached to the house.
Okay, and you say the garage that's attached to the house, so that's actually a portion of your house?
Correct.
And the
yes.
detached garage?
Correct. And
Okay.
the garage, I believe, was built in 2002. And I think the detached garage, we're not sure when, but at least prior to 2015, because it's on the 2015 survey. It's on there already.
Okay. So the house originally didn't have a garage as part of it, but one was built on in 2002. Is that correct?
That's correct, yes.
Okay. Property appraiser says your house was built in 1988. That's about right?
Yes, that's
Okay.
correct.
And then the garage was added, and then later, apparently, a detached garage?
Correct.
Okay. So those, I understand those, and then the other item is the fence. So talk a little bit more about the fence, please.
So when we drove into our neighborhood, Twin Branch Acres, we were like, wow, look at all these nice wrought iron black fences. They look really cool, and I would like one for the front yard so that we can let our dogs run. We have 2. We have a small 18-pound dog and a large 85-pound Bernedoodle. And it'd be nice to let them roam in the front yard because the backyard has a lot of trees and a lot of shade, so there's not a lot of grass, and there's a lot of dirt, and it's black, nasty dirt, so the dogs get really dirty. And we also have a chicken coop in the back, and our Bernedoodle loves to go and mess around with the chicken house. So to not have that happen, we thought, let's have a fence in the front yard, like the ones in the neighborhood, very, very similar. So that's why I'm here.
So your fence that you wish to install or have installed?
Wish to install.
Is similar to others in your community?
That's correct.
Do you have any photographs or addresses, or could you describe to me maybe where those are?
I did submit pictures with my application. I don't have them with me right now.
Okay, but they're in the record.
They're in
You
the
submitted
record,
them.
yes.
Okay. Are there any on your street particular?
I'm not sure. I don't think there are any on our street, but there are on like one street over, there are at least 7 or 8.
Oh, okay. All right. And then describe the fence again for me, please, that you intend to install.
So it would be like a black wrought iron fence that has like the little slats. I don't know how far apart they are, but yeah, just where, and I think the top part, we opted not to have the spokes that stick up to be just straight, and yeah.
All right, so it's not a chain link, it's not a solid fence, it's basically like a pickets or whatever, but.
Correct, but
Okay.
like wrought iron or, yeah.
Yep, okay. And the hardship related to your request, it sounds like it's just your dogs.
It's just the dogs, yeah.
Okay, all right. That's really all my questions then. If you have anything further?
No, that's it. Thank you for your consideration.
Thank you. Please be sure and sign in with the clerk. All right, is there anyone here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, do not hear anyone. County Development Services, anything further?
No, ma'am.
All right, and applicant, you had nothing further, is that correct? Okay, thank you. This will close the hearing on variance 23-0204.
Okay, we have one more variance for today, item H5, application 23-0213. The applicant is Nathan and Jennifer Carter, requesting a variance for accessory dwelling requirements. Staff findings will be presented by Isis Brown.
Good morning, Isis Brown, Hillsborough County Development Services, variance 23-0213. The applicant is requesting a variance to allow an existing principal dwelling to serve as an accessory dwelling after a proposed dwelling structure on a property zoned AS1. Per LDC Section 6.11.02C, a maximum of 900 square feet of living space is permitted in an accessory dwelling. However, a variance to increase the permitted living space may be requested when the residential lot is at least 14,520 square feet in size and living space does not exceed 1,200 square feet or 25% of the living space in the principal dwelling on the lot, whichever is less. The applicant is requesting a 236 square feet increase to the maximum amount of living space permitted in accessory dwelling to allow 1,136 square feet of living space. The lot is approximately 2.04 acres in size, and our findings, per the narrative submitted by the applicant, the new proposed dwelling is 4,550 square feet. Which consists of the amount of living space required for the variance to allow the 1,136 square feet of living space necessary for the accessory dwelling. However, upon review, the floor plan submitted of living space, the total square footage is 4,964 square feet, of which 4,282 square feet will consist of a living space. Therefore, staff has advised the applicant that the new principal dwelling must have at least 4,544 square feet of living space for the subject variance, if approved, to be effective. And final determination of the amount of living space will be made at the building permit review. I am available for any questions.
Ms. Brown, thank you. I'm not sure you can answer this, but what would the mechanism be if the variance is approved? to ensure that the residence, when it's constructed, is sufficient living space square footage to support the variance.
That's what we wrote in one of our findings, I believe. So at the building permit, they're going to review, and I'm guessing that the 45 needs to be met. So from what I understand, speaking with the applicant, the proposed dwelling is not set in stone, and they will review to make sure that they've met the 45, 44. That's in question. Did I answer that question?
Also, Madam Hittermaster, the code provides you the authority to attach conditions to variances. So if you feel it necessary, you can attach a condition that the variance is effective upon construction of a principal dwelling that has the necessary minimum living space. That way it would provide a heads up to review staff for the house.
Okay, thank you very much.
The new house that's being constructed.
Thank you, Mr. Hisney. Thank you, Ms. Brown. All right, applicant?
Hi, Nathan Carter, 8601 West Knights Griffin Road, Plant City. My parents were generous enough to gift us a parcel of their land, which includes a 100-year-old house, which is where we're currently living, and we're trying to build our new house on the same plot. It's kind of the next lot over. It's separated by a fence. It's kind of two separate things if you were to look at them from the street, but it is all still the same lot. So we're planning to build our new house on the same folio. We have a couple of versions of the floor plan. The floor plan is not absolutely finalized yet. When we were going over the initial design, we reviewed the LDC, and I'll look at this here, LDC 6.11.02.c, describing the living space. And we put our design to include the garage as part of the living space. The LDC says living space proposed for the accessory dwelling, let's see, where was it at? There we go. Thank you. Does not include motor vehicle garages and attics, provided such areas are not conditioned and are utilized solely for parking and storage purposes. So we had planned to condition the garage, and we were always planning to use it as a multi-use space. We have our home gym that we were going to put in the garage and have it conditioned. So to the letter of the LDC, I expected that the garage would count as living space. We certainly want to keep the existing house on the same lot. It's a 100-year-old house where we're currently living. Families lived in it over the course of, well, the past century. So we definitely want to keep that. So we're trying to make sure our new principal dwelling can approve, you can approve the variance so that we can have the new, our new house as well as keeping the old house. When we spoke to, we had originally spoken to a variance counselor several months ago. Unfortunately, I don't have the date or the name of the person that we spoke to. And they said that reading the way the code is written, they expected that the garage would probably be able to count as living space. We're not 100% certain. We're kind of unsure, again, after talking to, excuse me, after talking to case reviewer Isis Brown last week. She said she wasn't sure. So if the hearing officer decides that the garage, even conditioned and even used as more than just parking and storage, if that's not suitable to be counted as living space, we talked to our floor plan designer just this past week, and we have a revised, an alternate version, excuse me, an alternate version of the floor plan. Is that right side up?
Yep, and you can bring that microphone over. Just make sure that your comments are in it.
Okay. So we've prepared an alternate version of the floor plan. We would prefer to keep our original version of the floor plan, but just in case that the garage, the conditioned garage, is not permissible as floor space, we've added an extra 30 feet to the end of the floor plan over here. This adds another 300 square feet of living space and gives us 4,576 square feet of total living space, which is more than the 4 times required or more than the 4556, I believe, or 4554. In any case, regardless of the exact floor plan that we land on, we're well aware of the requirements of the variance, and we'll make sure that the final living space is in excess of what's required by the Land Development Code.
Okay, that's exactly what I needed to hear.
Okay.
As long as you're aware of that, and when you go through building permitting, they'll address that with you. Okay, and so I think I understand your request. The proposed accessory dwelling is actually an existing structure that you wish to keep.
That's correct.
And you wish to construct your primary residence on this same parcel.
Right.
And have that as an accessory. Okay. Anything further?
Nothing further. I hope we're able to keep the house, keep the existing old house as it is. It's got a lot of sentimental value and a lot of neighborhood value. Not in the record. We had some contact from some of the neighbors that we were in touch with, and they said, "Oh, we hope everything goes well. We love that little old house. It's been there longer than we have, so we really hope we can move forward with our new build and keep the old house exactly as it is."
Okay. All right. Thank you very much. Be sure and sign in with the clerk, please.
And I did bring some copies of the new alternate floor plan that I'll enter into the record as well.
Yes. Thank you. All right. Is there anyone here or online who wishes to speak in support of this application?
My name is Martha Ann Carter. I live at 8605 West Knights Griffin Road, Plant City, Florida. Nathan is my son. We are excited to think that they will be living next door to us. As my husband and I grow older, it's comforting to know that I'll have family next door in case I need them. The little house has been ours for over 50 years, and it's now theirs, and we would like to see it continue on the property too.
Okay.
Thank you.
Thank you. Ms. Carter, please sign in. Thank you. All right. Is there anyone else here or online who wishes to speak in support of this application? Do not hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? All right, don't hear anyone. County Development Services, anything further? No, all right. And applicant, anything further you wish to add?
No, thank you.
No, okay, thank you. That closes the hearing then on variance 23-0213.
That concludes section H of the agenda. We have no appeals, which then takes us to special uses, section J. We have one case, item J1. Special use application 22-1671. The applicant is Amber 2 of AP2 Services. The request is for a 4 COP alcoholic beverage permit, which requires separation waivers. Staff report and recommendation will be presented by Sam Ball following the applicant's presentation.
All right, applicant, we're waiting to hear from the applicant.
You're muted.
Can you hear me now?
Yes.
Okay, sorry about that. Good morning. My name is Amber 2. My address is 2002 Holloway Road, Plant City, Florida 33567. I am the agent for Stephen Jacob, who is the owner of Mango 7 LLC and the applicant. We are requesting a 4 COP AB permit to sell and allow consumption of beer, wine, and liquor on premises. We are also requesting 2 waivers because of the location. The first waiver is to be required, is to the required 250-foot separation from the residentially zoned property. And the second waiver is to allow more then 3 approved 4 COP uses within 1,000 feet of the proposed alcoholic beverage use. We are not requesting a waiver to the community use because we do comply with this requirement. This 4 COP requests will be for a club that will have a dance hall that serves beer, wine, and liquor. Due to the spacing and traffic buffer, the noise will be minimal to surrounding areas, and there will be no outdoor seating, which will also help to keep the noise minimal. There are no schools or daycares close to the proposed 4 COP use, and the business is planning to be open Thursday through Sunday, 6 p.m. to 3 a.m.
All right, Ms. Tu, could you address the waiver and your justifications?
Yes, ma'am. So there is on let me see here, Giggles Auto Sales. It was Roadhouse Bar. It is adjacent to the property. It's also a 4 COP, but it is now a auto repair shop. It's no longer the 4 COP is no longer in use for that establishment. There are, let's see here. So the Bullfrog Creek Bar and Liquor Store that also has a 4 COP. This establishment is 522 feet. That is in distance from the proposed wet zone envelope. Sorry. And let's see here. There is a supermarket that is 91 feet from the proposed wet zone envelope that also has a 4 COP license as well. Let's see. Just taking a look. So those, I do not believe that the supermarket is serving alcohol currently at this time. And yeah. And so the residential area, there is a buffer. There's a railroad track on the east side. Yes, on the east side of the proposed wet zone. And there would be that buffer there. The residential area, they would have to, cross that railroad track, which is not able to be done.
Okay, thank you. Anything further? All right, development services, please.
Good afternoon, Sam Ball with Development Services. I need to submit a revised staff report. There's a typo on page 2.
Okay.
I needed to correct.
All right, thank you.
Right, on page 2, it says 4 COP RX whenever they're really asking for 4 COP.
Okay.
The applicant is requesting 2 distance separations for a 4 COP alcoholic beverage development permit to allow the sale of and consumption of beer, wine, and liquor on and off the permitted premises. The wet zoning is sought for a proposed nightclub to be located at 11116 US Highway 41 South within an existing commercial center. The proposed wet zoned area will cover 15,972 square feet, comprised entirely of indoor area as shown on the revised wet zone survey stamped and received on March 30th. The applicant gave a thorough presentation of her facts. I'd like to go straight to staff findings. LDC 61111E3 provides for the approval of separation waivers where there are special or unique circumstances where the alcoholic beverage use applied for does not have significant impacts on the surrounding land uses and certain circumstances negate the necessity for specified distance requirements. Staff concurs with the applicant's justification regarding the the distance waiver request from residential zoning district, and the 1,000-foot proximity restriction to a maximum of no more than 3 approved 3 PS, 2 COP, 2 COPX, 4 COP, 4 COPX, 4 COP SX, 4 COP SBX, or 11C alcoholic beverage uses. The residential zoning district line that is located 95 feet to the east of the proposed wet zoning is within a functioning railroad right-of-way, whereas the distance from the rear of the proposed wet zoning to the front property line of the nearest single-family home to the east is approximately 245 feet. The pedestrian and vehicular route of travel from the entrance of the proposed dance hall to the driveway of the nearest single-family home to the south is more than 1,000 feet in length, while travel to the single-family home to the east is effectively blocked by the railroad tracks. The proposed wet zoning does not include the building area at the south end of the shopping center and therefore will be buffered by a different tenant from the residential uses to the south, while dense vegetation on both sides of railroad tracks will buffer the single-family homes to the east. The dance hall and parking will be oriented towards US Highway 41 south, away from the residential uses to the east and south. Staff has received no objections from the notice residents of the area. The applicant has agreed to limit the sale and or consumption of alcohol to from Thursday through Sunday from 6 p.m. to 3 a.m. the following day, which is substantially less than what's allowed by the Land Development Code. Only 3 of the 5 other existing wet zonings of the specified types are located in the same shopping center as the proposed wet zoning. The other 2 wet zonings are separated by roadways from the proposed wet zoning and therefore have no functional relationship to the proposed wet zoning, thereby mitigating the cumulative impact of the total number of existing wet zonings. For these reasons, staff finds the proposed wet zoning does not pose significant impacts on the surrounding land uses, thereby negating the necessity for the prescribed separation requirements. Therefore, staff finds the proposed 4 COP alcoholic beverage permit to be approvable, subject to the condition that the sale and or on-premises consumption of alcoholic beverages shall be limited to from Thursday through Sunday from 6 p.m. to 3 a.m. the following day. That concludes my presentation. If you have any questions.
Thank you, Mr. Ball. No questions for you.
Thank you.
All right, is there anyone here or online who wishes to speak in support of this application? Don't hear anyone. Is there anyone here or online who wishes to speak in opposition to this application? I don't hear anyone. All right, Development Services, anything further?
No, ma'am.
Okay. And applicant, did you have anything further you wish to add? All right.
Sorry.
Don't hear anything? Okay. That will close the hearing on the special use, AB 22-1671. And that concludes our land use hearing meeting for today. Thanks.